I had the chance to meet many of you during the breakfast, and I'm so pleased to welcome you here. Last week, we were celebrating Data Privacy Day, and we had many scholars from around the world here at the law school to look at privacy regimes, both in the United States and in Europe and elsewhere. And I think having these two conferences almost back-to-back is a good indication of the commitment of this law school to comparative and international law. You obviously chose to come to Duke. That was a choice of law school decision, and I think you chose very well. We have a great tradition here. David Cavers, and of course Brainerd Curry. The Curry family and my family, the Levi family, are quite interconnected. Brainerd Curry, I grew up in Chicago at the University of Chicago, where my father was a faculty member and dean of the law school there. Brainerd Curry was on that faculty for some good period of time and on this faculty as well. His son David, who passed away just very recently, held the chair named for my father. So it's a particular pleasure for me to pay tribute to Brainerd Curry here today. Bill Reppy on our faculty as well is distinguished in this field. What I would really like to say is that the Duke Law School's commitment to this topic and this field is not simply traditional, but very much part of what we do now. And so may I pay tribute to Ralf Michaels, who I think we all have very high hopes for. He is a worthy successor to Brainerd Curry. He put together the materials for this conference. They're of very high quality, and we have very high hopes for both the presentations and the discussions here today. Ralf is not just simply a wonderful scholar, very creative, but a wonderful colleague as well, and a nice person, and I think all of us here would thank him for the organization of this conference and doing it so nicely and so thoughtfully. So I wish you very well in your deliberations. I'm going to listen in as much as I can. Thank you very much for being here this morning. Thank you.
Yes, good morning. Welcome, everyone. Thanks, David, very much for praising me so much. Of course, I gave him the text for that to make sure the praise would be high enough. I'm here in two functions, really. One is to be the director of Duke's relatively new Center for International and Comparative Law, which has been established to serve as an umbrella of all international comparative law events at the school, but also to have events of its own. And one of these events is this one. So the second function that I have here is to be the convener of this event. And of course, I figured if I run the center this year, I should also get to determine what we should do and who should come. So I'm very glad that all of you came to this conference, and I hope that indeed we will have a very interesting and fruitful event today. The theme of this conference, European Choice of Law Revolution, Lessons for the United States, of course, was formulated in a hyperbolic style that I try to view as American foreigner that I still am, and as an even-handed provocation, as a provocation to Europeans to say what you have is actually a revolution, because of course Europeans don't like to think of what they do, especially in conflict of laws, as a revolution, and as a provocation to Americans to say there is actually possibly something to learn from Europe, because we haven't really done that very much, at least in conflict of laws, until quite recently. I will not say why I think this is a revolution. I will spare that until you have to bear with me on the panel later. For now, I'll just say it's great to be thanked for putting this together, but this is really an event put together by several people. This is in collaboration with the Tulane Law Review, and Hala will say something more later. They wanted to do a comparative conflict of laws conference. We wanted to do one. We figured the country was ripe for one, but not for two, perhaps, which is why we got together. And this has actually proved so far a very congenial and good collaboration. And of course, I should thank Neyland Durrell, who is not in the room, but who has worked days and nights to put everything together, and Stephen Bornick, who's the associate director of the center and who's probably also worked so late last night that he needs his sleep today. If you have any technical requests or other requests, ask Neylan or ask myself. during the day. We will have panels. We will have some technological possibilities for PowerPoint presentations, etc. We will break for coffee breaks and other breaks and go back to the loggia that you've seen. But most of all, what we will have here is not just coffee breaks and not just PowerPoint presentations, but a lot of really fruitful and helpful conversation. From having read through the papers and abstracts that I've seen, I've realized in that we have the potential of such a conversation because European views of European law and American views of American law are strikingly different. And of course, European views of American law and American views of American law are strikingly different. And they may remain different after this conference, but I hope that we will have a conversation on why they are different and what we can learn from the other's perspective in the way in which we promote comparative law as something useful, even if it doesn't have a direct output in the end. And with that, I'll finish for now and pass over to Hala Jackson, who's here from the Tulane Law Review. Again, thank you very much, everyone, for coming.
I'm Haller Jackson, and on behalf of the Law Review, I'd like to welcome everyone, and thank you for coming. When the collaboration was first proposed, I don't think we had high hopes, but when I saw the final list of participants that Professor Michaels, who has borne the lion's share of the organizational responsibilities, had organized, I was blown away. I was positively thrilled, both because all of you are leading lights in your respective fields, but the fact that there was an opportunity to bring such a diverse group of scholars together to have a conversation, I think does present the possibility for exactly the type of conversation and hopefully some type of synthesis, as Professor Michaels was mentioning before. The papers that I've seen so far, and those that I'm sure I will see shortly, nudge, nudge, have been fantastic, and I have to say, the review couldn't be more pleased to publish them. We've had a long-standing commitment to comparative law. It's been a masthead topic for a good period of time, and also to the civil law because of Louisiana's tradition in that area. And so we're pleased to have both a comparative emphasis in the conference and to have participants from civilian jurisdictions. So again, thank you so much. I'm very pleased to be here. And again, I'd like to thank Professor Michaels, and then the person who, from the Law Review's end, Mary Nagel, has been instrumental, not just in organizing, to the extent we've had logistical, we've offered some logistical help up until this point, but who will organize our effort going forward. She's not only done this for the conference this weekend, but the Law Review is hosting a conference on multi-district litigation next one, so back-to-back conferences. That one will be hosted in New Orleans, where choice of law, of course, given the recent legislative proposals in the area, will again be a topic. So I'd like to thank Ms. Nagel, and again thank Duke and Professor Michaels for having assembled such a fantastic group of people. We're very pleased to be here. Thank you.
Yes, so we will have the first panel on contract and torts, and my colleague Paul Haagen will chair the panel, who teaches contracts, legal history, sports law, and knows everything else, so will be a wonderful moderator. Paul.
Should have the panelists come
Yes,
up
we
now.
should also
Yeah.
have a panel, because although he knows everything, it would be great to have
To have someone to.
him. And he will introduce who you are.
It's common at these events to have fairly elaborate introductions of the panelists, and I propose, since the revolution has come, to change that and to make very short introductions, so there is actually the possibility of more time for serious interchange. We have a very distinguished panel. They will be going in the following order. The people who are addressing torts will come first, and the order will be European American, since the revolution is coming, and then I guess the lessons or something like that. So in order, the first speaker will be Jan van Hein, who is professor at the University of Trier, where he's held chairs for German and comparative and international law since 2007. Next will be Dean Symeonides, who, excuse me, is not on my list, but who quite literally needs no introduction, has been a leader in the field of comparative and international law, conflict of laws for a very considerable time. And I'm going to stop the introductions there so that we get the tort issues first and then move on to contract.
Well, first, good morning, and let me express my gratitude to Ralf Michaels and all the others who have organized and invented this conference. I'm very glad to be here, and thank you also for the kind introduction. And since I have only 15 minutes for my talk, this must be enough of polite thank yous, and I'll start with my subject. Well, Rome II and the European choice of law revolution, or is it rather a European choice of law evolution? When I was asked to talk about the subject, the formulation of the subject of this conference made me think about this question whether we are actually witnessing something like a European choice of law revolution. Of course, revolutions have an entertaining aspect, public beheadings and all this sort of thing, but I thought, is it really a revolutionary thing if we think of the Rome II regulation, or is the Rome II regulation more properly conceived as the product of a long time evolution of domestic states, domestic laws, private international law of the member states? Well, most member states, or almost all member states of the European Union, still follow the conflict of laws methodology that was invented or found its classic formulation by Friedrich Karl von Savigny in the 19th century. Let me just repeat the core elements of this Savignian approach. The Savignian approach is, to use an American formula, jurisdiction selecting. That means that Savigny did not look at the substantive content of various laws as the older statutist method did, but he rather put the question the other way around and asked where a certain jural relation, a Rechtsverhältnis, has its seat. Today we would frame the question more in a way with which state is the jural relation most closely connected. Why did he turn this question around? Savigny's underlying idea was that private international law should strive to facilitate international harmony of decisions. A case should be decided with the same outcome regardless of the forum in which a case is brought. And the underlying idea was that in this way parties should be able to anticipate the outcome of cases without having regard to the forum where the case might eventually be litigated, which you never know beforehand unless you have a forum selection clause. And that by promoting international harmony of decisions, transaction costs for the parties would be lower. Of course, he did not use such modern language, but this was basically the idea behind it. With regard to torts, Europeans are today rather more papal than the Pope himself, because Savigny considered tort law as strictly mandatory positive law. He himself was not in favor of the lex loci delicti, but that was a minority position then, and following generations of scholars adapted the Symeonian method that he advocated in general to tort law as well. So this approach was still followed by the member states of the EU. We saw a wave of codifications from the 1970s to this millennium. In fact, after the European Union had decided to pass Rome II regulation, some member states even started last-ditch efforts at codifying their law in the hope that having a new and modern law would give them more influence at the European level. The basic elements of the member states' codifications are more or less the same. There are variations on a theme. Basically, most codifications start with lex loci delicti, but then the codifications allow for a certain degree of flexibility by having a common domicile rule, and some codifications also have an explicit escape clause, which allows judges to disregard lex loci delicti or the common domicile rule under particular circumstances. Some, especially the more modern codifications, allow for party autonomy in tort, choice of law. The more reticent codifications allow party autonomy only after the event. More modern codifications, such as the Dutch law, also allow for party autonomy ex ante. Another instrument which allows more flexible results in the individual case is the so-called accessory connection. If a tort is closely connected to a contract, for instance, then the law that governs the contract is also applied to the tort claims. These elements are varied. Not all member states have them. Some are especially reluctant with regard to party autonomy and accessory connection, which may be labeled a kind of indirect party autonomy. But if you look at the codifications, you find more or less reassembling of the same basic elements. And these elements also had the impact on the Commission's first proposal of 2003, which started, not very surprising, with lex loci delicti, which could be disregarded by the common domicile rule. It had an escape clause, it allowed accessory connection, and it even allowed party autonomy, but only after the event. And apart from these general rules, the Commission's proposal contained several specific rules for certain types of torts, such as product liability, environmental damages, violations of the right of privacy, and rights relating to the personality. This was also an approach that could be found at the member state level, having a set of general flexible rules on the one hand, and on the other hand, in the interest of legal certainty, to have specific rules which modified the general rules with regard to certain types of torts. So this Commission's proposal was more or less a normatively weighed restatement, and no revolutionary top-down solution which contained completely new approaches. This was not self-evident because there had been challenges to the classic Savignian approach recently. On the one hand, we have witnessed growing influence of primary EC law on conflict of laws, especially in corporate law, where the ECJ discarded the traditional continental European real seat theory in favor of a competition of legal orders. We have witnessed a growing influence of primary EC law in the area of family law. But with regard to tort law, there hadn't been much revolutionary impact. I deal with this in more detail in the paper. With regard to tort law, especially unfair competition law, secondary EC law was more important. There was a directive called the E-Commerce Directive, which, according to many authors, enshrined a so-called country of origin principle, and there was a lot of lobbying by the industry and trade groups to enshrine a country of origin principle in general tort law as well, which would then have led to a very strict application of the place of acting or the place where a corporation is located as the dominant connecting factor in tort choice of law. But at the end of the day, all this lobbying was not successful. Apart from these intra-European challenges to the classic approach, there were several US-inspired approaches which had an influence on the discussion. First of all, there was a kind of competition between the proposals for a Rome II regulation and the older Hague conventions on product liability and traffic accident. Since Marta Pertigas is here, I won't say anything nasty about the Hague Conventions, although they are so old that she has no responsibility for them. These conventions employ a method that was in a certain way imported from the United States, a so-called grouping of contacts. They employ a kaleidoscopic scheme of various connecting factors which are combined in a certain fashion, and if two or more of the connecting factors coincide, then the law of this state is applied. This is very complex, so I can't go into details here. The end results are more or less convincing, although it was always criticized in Europe that the conventions do neither allow for an accessory connection and do not nor for party autonomy in tort choice of law. But the basic problem for the European legislator was that the states parties to the Hague Conventions, which formed only a minority of member states, were quite happy with the conventions and did not want to give them up. So, especially in the area of traffic accidents and product liability, there was a sort of competition. If the European Commission wanted to make these states accept the Rome II regulation, then somehow they had to convince them that the Rome II regulation was better than the Hague Conventions. There also had been, or some authors tried to discern American influences on member states' law. For instance, the common habitual residence rule, the common domicile rule, was traced to American influences by some authors, but in fact this rule is much older. Also, the principle of ubiquity, which is familiar in German law and Italian private international law, which means that to buy local torts, either the law at the place of acting or the law at the place of injury is applied, was seen by some as the reception of the American better law approach, but in fact this is also an older rule which had already been applied by the German imperial court more than 100 years ago. And then there was a very significant American influence on the further discussion of the Rome II regulation after this rather traditional Symeonian Commission's proposal came before the European Parliament. Parliament, led by its rapporteur, Diana Wallis, tried to abandon almost all specific rules for certain types. So the rules for product liability and environmental damage, for example, that were found in the Commission's proposal should be abolished. This would have, of course, significantly increased the weight that the general rules would have to carry if you no longer have these specific rules for certain kinds of torts. So the European Parliament proposed to beef up the general escape clause and to rewrite it in a way that was similar to Section 6 of the American Second Restatement, with a laundry list of connecting factors that judges would have to take into account. Also, the Parliament's proposal was much more open to the concept of dépisage, to an issue-specific analysis of choice of law questions. And it increased, and that was a good thing, I think, party autonomy in tort choice of law. The Parliament's draft also allowed party autonomy ex ante and not only ex post. The reactions to these proposals in European academia and politics were decidedly mixed. There was a conference in Italy in December 2004 in Castellanza, where several European academics gathered to discuss the Parliament's proposals, and most of the comments were negative. There was also a conference with American and Canadian law professors. There the reaction was more positive. I always found it a bit strange to have two separate conferences with Americans and Europeans on the one hand, and I'm glad that today we have both Europeans and Americans here to perhaps engage in a discussion that should have taken place then. Well, at the end of the day, the reactions to the amendments by Parliament were largely unsuccessful, except for party autonomy, which was given a wider scope in the final Rome II regulation. But the specific rules for certain types of torts were mostly reintroduced, except for personality rights, which suffered from a political blockade. But the basic concept of the final Rome II regulation is very close to the original Commission's proposal. We have lex loci delicti as the starting point. Then we have common habitual residence. We have an escape clause, which also allows for accessory connection. We have party autonomy, ex ante, not only ex post, at least for commercial parties. Of course, you have to protect consumers and other weaker parties. And we have the rules governing specific torts, such as product liability. There we have a very complex rule, which is modeled on the Hague Convention in certain ways. It was an unsuccessful attempt to make a European rule palatable to the, or acceptable to the member states parties to the Hague Convention, but this did not succeed. The Hague Conventions, both on products liability and on traffic accidents, will remain in force, and they will remain applicable even within the EU, so we don't have a full legal unity in this respect. With regard to environmental damage, we have a rare example of a substantivist, openly substantivist rule in the Rome II regulation, despite its general Symeonian framework. The final Rome II regulation favors the victim in these cases, who may choose the law more favorable to him or her, but this is not done out of sympathy for the victim, but rather to enhance or increase the level of environmental protection. So, at the end of the day, the Rome II regulation is very much still rooted in classic Symeonian conflicts thinking. From my point of view, this is more or less a good thing, since the solutions that we find in the Rome II regulation today more or less have been tested in member states' law during the last decades. All these rules and the elements in these rules have been tested by member states' courts. They have been subjected to comparative analysis by European academics. So from my point of view, it is rather an advantage of the Rome II regulation that it does not contain any completely new revolutionary solutions. Practitioners all over Europe can build on the techniques that they have learned by applying former domestic laws. They can still use some of the older, most of the older cases and the literature. Of course, we have to rethink all these older materials, and we have to reframe some questions, but from a from the point of view of efficiency, it's probably a good thing that we don't have a completely new revolutionary top-down solutions, but that that we can continue on the path that we have followed in the past. So I conclude on a very positive note with regard to the Rome II regulation, and then my esteemed colleague Symeonides will tell you why everything that I've said here today is wrong and why the Rome II regulation is actually very bad, and then we can have a discussion. I thank you for your attention. Thank you.
Dean Symeonides has the wonderful added benefit here that he will come from both the east and west of Professor von Hein, starting in Greece, now ending up in Oregon.
Thank you. In fact, I would like to note that I'm truly a hybrid in the sense that I'm both a European citizen and an American citizen. I was born in Cyprus, which is now part of the European Union. So in that sense, I'm a hybrid. Are we ready with the technology? Yeah. And do I have a remote? It's really an honor to be at the school where both Brainerd Carey and David Cavers taught. They are my heroes. Which is not to say that I agree with everything they have written, but at least in the case of Cavers, pretty much. He was my teacher, I'm proud to say, but he, of course, is not responsible for what I ended up doing. So I would like to thank Ralf for bringing this panel together. The pleasure of this gathering is really not so much what we will say from up here, but the opportunity to have this exchange afterwards. And so I look forward to your comments. Our topic, as defined by Ralf, is the new European Choice of Law Revolution: Lessons for the United States? ? There. As Jan suggested earlier, maybe the question mark should be in the main title, is there really a European Choice of Law revolution? But in any event, whether or not there has been a revolution, it's a good question whether we can learn from it in the United States. And my answer is decidedly yes, we can learn from it. There are many critics who question really whether what is happening in Europe, what has happened, is in fact a revolution. I think there is a revolution of sorts happening there, and it's not so much Rome II as such, that is the substantive solutions of Rome II, which I find, as you will see, rather disappointing. But I think the revolution is the Europeanization of, or federalization of conflicts law. And that is something from which we can learn in the United States. It seems that Europe is learning, is accomplishing in a relatively short time much more than we would ever try to accomplish in this country. But of course, I do recognize that federalization of conflicts law, or even small parts of it, are controversial in this country. And even talks about a new restatement run into opposition. So obviously, these are matters with regard to which people can reasonably disagree, as I know they disagree in Europe. The whole question of Europeanization of conflicts law is itself controversial. It's been mixed into politics and so on. So now, American conflicts law is one of those few branches of American law that really owes its origin to European continental sources rather than English sources. And you all know the historical reasons for that. So for at least methodologically and philosophically, European private international law and traditional American conflicts law were quite similar until the middle of the 20th century. This is not to say that they followed the same substantive solutions, but they were similar in many other respects, methodological and philosophical and so on. For example, they're both multilateral as opposed to unilateral, at least for the most part. They are jurisdiction selecting, choosing the law of a country because of its territorial conduct rather than the content of its law. They relied on fixed rules, which themselves were based on single connecting factors, or a single connecting factor, and they both aspire to produce legal certainty, very important value, especially in continental Europe, but also in the first restatement, uniformity and conflicts justice as opposed to material justice. And both systems adhere in the area of torts, which is my topic today, to the rule of either lex loci delicti or lex loci damni. I use the latter term to mean applying the law of the place of the injury, and the first term to mean applying the law of the place of the conduct that led to the injury. In the United States, of course, the first restatement categorically opted for the law of the place of injury. In Europe, some systems went one way, some systems went another way, conduct or injury, or both, or whichever is preferable, and so on. So in Europe, there was not much uniformity, unlike the United States. So methodologically, the two systems were very similar. Substantively speaking, in terms of the actual choice of rules they adopted, they diverted quite a lot in the 19th and early part of the 20th century. For example, if you take the two grand principles of private international law, the principle of territoriality and the principle of personality, I know these are generalizations. I think it's fair to say that the European continental system relied more on the principle of personality than on the principle of territoriality. Think of, things outside torts, what law governs successions, matrimonial property, even contracts. So whereas the American system was based much more on territoriality rather than on the principle of personality. And if you take the two areas of laws and of torts and contracts, you will see that the American system is completely territorial, the traditional system, lex loci contractus, the place of the making of the contract, nothing else, no recognition for party autonomy. We don't apply the law of domicile even for issues of capacity and so on. And of course for torts, lex loci delicti and nothing else. In Europe, the system is territorial in torts, but not in contracts because they always recognize party autonomy and always applied the law of the domicile for issues of capacity and similar issues. So that's how the two systems were until the middle of the 20th century, and then in the United States, we had what is now known as the American choice of law revolution, and really the leader of the revolution, you could say, was as early as 1933 David Cavers, but then the really chief was Brainerd Carey in the 1960s. And so one after the other, American jurisdictions have abandoned the rule of lex loci delicti in tort conflicts, starting in 1963 with Babcock, ending now after the turn of the century. Only 10 states adhere to the lex loci rule and to the traditional choice of law theory in general. So in terms of numbers, the revolution has prevailed, no question about that. But whether the revolution has also succeeded in bringing about a new system, that's a big question, and unfortunately the answer to that is no, and that's what we'll be talking about today. Now, the revolution did bring about major methodological and philosophical changes. If we take the basic features of the traditional theory and compare it with what is being followed today, you will see that instead of rules, we have so-called approaches, namely flexible guidelines that don't really give you the result. They are based on multiple factors rather than a single connecting factor. Unilateralism has resurfaced in the works of Brainerd Carey and others. So, and even in the restatement, it is mixed with multilateralism. The system is only partly territorial. Even in torts, we now have the common domicile rule. It's content selecting as opposed to jurisdiction selecting, and it's based on policy. It's no longer, at least doesn't purport officially to be neutral towards the law of the forum. It's forum sensitive, perhaps forum chauvinistic in some places, like Kentucky, for example. And we not only aspire for conflicts justice, but material justice is now one of the goals, and in some particular approaches is the goal, like the better law approach. So, in other words, the American choice of law revolution has brought about significant, perhaps cataclysmic methodological and philosophical and terminological especially changes. However, in terms of substantive outcomes, the revolution has not really brought about major changes, as I hope to demonstrate in a minute. Now, compare that with European experience. In my view, there has been no revolution in choice of law codifications and thinking in Europe. There has been a quiet and I think quite effective evolution. But the results, the substantive outcomes, have changed in ways similar to those of the United States without a disruptive and costly revolution. So let's see that with specifics in the area of tort conflicts. In the United States, we have many courts have adopted this distinction between conduct regulation and loss distribution issues that I will hope to explain later on. It is, I think, an important distinction, even if some people disagree about its actual application in specific cases. So, if the parties, the tortfeasor and the victim, are domiciled in the same state, then regardless of where the conduct and or injury occur, American courts, starting with Babcock, apply the law of the common domicile. So they have adopted for this pattern of conflicts the principle of personality rather than territoriality. Well, this is the essence of the American choice of law revolution in terms of substantive outcomes. That is the only thing that changed. Not much else has changed, really, as you will see in a moment. So if the issue is one of conduct regulation rather than loss distribution, then what are the possibilities? If conduct and the injury occurred in the same state, then we apply the law of that state, both the conduct and injury, regardless of the domicile of the parties. And the other possibility is that the conduct will be in one state and the injury in another, what I call cross-border torts. What we do in the United States is to apply the law of either the place of conduct or the place of injury, whichever has the higher standard of conduct. The one is a false conflict, the other is a true conflict. But in both of these categories of cases, what we are applying is the lex loci delicti, and the only difference is that in one case it could be either the law of the place of conduct or the place of injury, but it still is a territorial solution. What that leaves out is, going back to loss distribution issues, split domicile cases where the tortfeasor and the victim are domiciled in different states. And there are two possibilities there, that the conduct and the injury would be in the same state, so intrastate torts, but involving people from different states. In that case, we apply the law of the conduct and injury, regardless of the domicile of the other party. Again, therefore, a territorial solution. And that leaves cross-border torts, where, again, we apply the law of either the conduct or the injury, whichever is higher. So these are essentially territorial solutions, again. Personality sometimes becomes a factor. The domicile of the party is an additional factor to be considered, but really, in terms of final outcome, the solutions are actually territorial. That is in very abbreviated form, of course, the essence of the American choice of law revolution in tort conflicts in terms of substantive outcomes as opposed to philosophical methodological outcomes. Now, what is happening in Europe? Again, the general rules, leaving out the specific rules about competition and this and that. The basic rule adopted by Rome II is the lex loci damni, namely applying the law in place of injury rather than conduct or indirect consequences of the injury and so on. That's how they define it. Unless the parties are domiciled in the same state, in which case you apply the law of the common domicile, as in the United States, which is not to say that it was taken from here, but it's the same final solution, or unless the tort is manifestly more closely connected with another state, in which case you apply the law of that state. That is their escape. Other European systems before Rome II essentially have ended up with the same solutions, except that, like the German and the Italian system, for example, they don't tie you to the law of the place of injury. It's either the place of conduct or injury at the option of the victim. All of these systems also have a caveat in another article that account shall be taken of the conduct and safety rules of the state in which the conduct occur. This is an oblique and timid recognition of what I called earlier in the distinction between conduct regulation issues and loss distribution issues. But we'll see that there are still some important differences between the two. So then, bottom line is that in Europe, as well as in the United States, territoriality continues to reign, except in the common domicile cases. Now, if you go back to Babcock, the case that started the American choice of law revolution, the court said the question for us today is whether the law of the place of the tort will invariably govern in a tort conflict or whether we should look into other factors. And finally, that court on that day answer the question by saying it should not invariably govern. In some cases, depending on the issue, loss distribution issues, common domicile situations, we are going to apply the law of the common domicile. And 40 other American jurisdictions have reached the same result. And this is the American Revolution. Okay. Now, as we have seen a minute ago, European codifications and now Rome II have also ended up with the same results. They introduced the exception of the common domicile for common domicile situations. After Babcock, the only worthwhile debate was what to do with cross-border torts and whether we should apply the law of the place of conduct or the place of injury. And as I indicated a moment ago, we apply whichever of the two has the higher standard of conduct for the tortfeasor or the higher standard of financial protection for the victim. We don't give the choice to the victim, but the court makes the choice, each time reinventing the wheel. My goodness, okay. And what the Europeans have done in some countries, in Germany, Italy, Hungary, is to give the choice to the victim, which is actually a much more clever device, and you don't have to reinvent the wheel every time, and the court doesn't have to come up with all these policy rationalizations and excuses and so on. So these are the differences. Are those differences worth a revolution? So what are the lessons for the two sides from these two experiences? I will have to go quickly through the rest of my materials because I wasted my time earlier. So lessons for the U.S. Before revolution, try evolution. Maybe you can accomplish the same results. If you opt for revolution, set specific goals and have an exit strategy. Think of the day after, the morning after. You want to demolish this system, that's fine, maybe it deserves to be demolished, but have you thought about what to do next? I don't think we thought of that. And Brainerd Carey, bless his soul, he denounced all rules because he thought all rules were evil, whereas the problem was with some rules which were pretty bad. So if you go the revolution route, well, have an exit strategy. A revolution should not last forever. The American choice of law revolution, as a friend of mine said, John Koziris, has been pregnant for too long. It's about time that it gives birth to something. And so what we can learn from Europe is that choice of law problems are susceptible to legislative solutions, and we can come up with new rules which will not have to sacrifice the gains and accomplishments of the revolution. Elsewhere, I tried to demonstrate exactly how those rules should be, both in actual legislation and in other writings. And finally, and this is far more controversial, unification of American conflicts law in the form of a new restatement or through some other vehicle, or even federalization is not anathema. I know it's not people's first choice and needs to be discussed at length, but we shouldn't start with the premise that it's an absolute non-starter. Lessons for Europe now. Issue-by-issue analysis is not evil. You are so fixated about avoiding the passage that you use a too blunt an instrument by depriving yourself of issue-by-issue analysis. You are trying to avoid the passage, and yet you cannot avoid it. You have more of it than you think. In my last piece on Rome II, by the way, which is in the American Journal of Comparative Law, I give 10 examples where Rome II leads to the passage. And that is in a system that was adamantly set against the passage. You know, when the Parliament proposed some amendments that we advised the rapporteur, the Commission said, no, we don't want the passage. But you have it 10 times, you know. So the problem with the passage is how much and when and what is appropriate and inappropriate depassage, and there are safeguards to guard against inappropriate depassage, but don't prohibit it altogether. Stop pretending that states have no interest in the outcome of private law disputes or choice of law disputes. They have plenty of interest, and you do recognize it, and you have many rules that are based on that premise, from unilateral rules to loi d'obligation immédiate to even ostensibly neutral bilateral rules that are essentially drafted in order to protect certain state interests or public interests, including even the new rule on products liability in Rome II, for example. Don't be too fixated with certainty. The more you push for it, the less of it you will have. Finding the golden mean between the certainty and flexibility is difficult, but you are too much on the side of certainty. Example, the escape clauses of Rome II, for example, and many of the other codifications, though not all, the English codification being the good exception, they are too tight. They do not allow issue-by-issue deployment. They are phrased in all or nothing terms, exclusively geographical, not tied to an overarching principle. Under Rome II, in order to use the escape, you have to show that the entire tort or delict is manifestly more connected with another state. Whereas in many instances, that's not the issue. The tort may well be connected with one state, but with regard to one issue, like who gets to bring the wrongful death action, or how much damages you can recover, or whatever, that issue, with regard to that issue, another state has a manifestly more closely connected. So then I need to skip quite a few slides about the conduct regulation, loss distribution distinction, and go on to the common domicile rule, for example, of Rome II, which in summary, it's great that Rome II finally adopted the common domicile rule because and other European systems have done the same. But the problem with the common domicile rule is that here I am. It's too broad because it's not limited to issues of loss distribution. So, for example, you have two people from Austria having an accident in France. Under the common domicile law, you apply the law of Austria. And that's great with regard to many issues, but not when it comes to issues of conduct regulation. And I'm not only talking about traffic rules. I'm talking about other possible, other issues that qualify as that. So the rule is too broad in that sense. You went too far by not following the distinction of conduct regulation versus loss distribution. But in a different sense, the rule is also too narrow because it requires parties to be domiciled in the same state, but it should also cover situations where the parties are domiciled in different states which happen to have the same law. For example, if you have a Belgian and a French citizen who are in a safari in Kenya and they injure each other, there's no reason to apply Kenyan law if Belgian and French law are the same with regard to the amount of recovery, for example. Now, if there is a pre-existing relation between the two, that should take over, but if there is no pre-existing relation, under Rome 2, you will have to apply the law of Kenya, even though Kenya would have no more connection. And finally, something about party autonomy. It is, I've read too many cases in the American side to know that party autonomy, as good as it sounds, has become a euphemism for screwing the little guy. And that is bad enough in contract cases. Now to have it in tort cases, in pre-tort agreements, I think is just scandalous. And I know we have friends who like party autonomy very much, but I think this is tort situation we're talking about. Fortunately, we are able to convince the rapporteur to include some safeguards, but I don't think the safeguards go far enough. Consumers are protected, but there are a lot of little guys who are not protected. If you are engaging in commercial activity, essentially, there is no further protection. And I submit to you that there are many, if you take a typical franchise contract, it's commercial activity. And yet the franchisee needs protection, which in this country we provide, even though otherwise we're not very solicitous of consumers. So there are problems with the principle of party autonomy. It went too far. Sorry I took too much time. Thank you for your attention.
We now move into that aspect of law which is about screwing the little guy. Dennis Soloman will address conflicts with regard to contract law. He is professor of civil law, private international law, and comparative law at the Eberhard Karls Universität Tubingen and en route to Passau.
Hello, that was fast. I wasn't counting on already having to talk now. Well, this is my turn to thank Ralf very much for the invitation to present some ideas which on the European conflict of laws, which may be attributed to Europe, but possibly could also be attributed to myself. So if anything seems to be strange about what I'm going to say, maybe it's not because the Europeans have not understood what they're doing, but maybe it's my fault. I will like to proceed like this, even though time is short. I would like to start with paying tribute to a venerable academic principle that some of my colleagues have already paid tribute to. That is, if you're not the one to have chosen the theme of the conference, you must begin with a critique of that very theme. So this is my turn to say that I do have some doubts whether this is a revolution that we're having at the time in Europe with regard to the choice of law. Now, of course, as we know, contract conflicts have been subject to the Rome Convention for quite a while now. So if we are talking about the Rome Convention system, we could probably not very well talk about a revolutionary system. It might have been revolutionary at its time. I will not discuss that, but it is not revolutionary anymore. Now, as we also know, this system is about to be revised. We have a proposal for a Rome I regulation, which is meant to replace the Rome Convention, dating from 2005. But even with regard to that proposal, I would hesitate to talk about a revolution. This is because the Commission's proposal did not bring about a fundamental change in the basic premises of the Rome Convention. Rather, the proposal must be considered as more of a continuation of the conventional system. On the other hand, it cannot be denied that the Commission did propose certain changes in specific aspects, which might aptly be called revolutionary. Therefore, what we had in 2005 was not a complete overthrow of the prevailing system, but rather what I would prefer to call individual revolutionary advances. Yet the tide has turned again. As recently as December 2007, a new version of the proposal was adopted in which many of the most revolutionary changes have been retracted or attenuated again. The advances originally made have thus given way to a considerable retreat. Returning to this conference, even though there might not have been a revolution in European conflict of laws, I would still like to briefly sketch what I consider the most important facets of the current state of the European private international law of contracts. On a very general level, I think it could very well be argued that the two approaches, systems, or whatever we want to call it, in Europe or in the United States are not that terribly far apart. The interest lies more in detail, so I would like to beg forgiveness if I go a little more into specific rules with regard to contract choice of law. Somewhat atypically, I would like not to start with party autonomy, but instead with the objective conflict rules for cases where the parties have not chosen the law applicable to their contract. This is because the special regimes for mandatory rules in Europe can, in my view, at least in part, only be properly explained before the background of the existing objective conflict rules. The basic principle of European choice of law in contracts will remain untouched. Where the parties have not chosen the applicable law, the contract will generally be governed by the law of the country where the party effecting the characteristic performance has his habitual residence. This focus on the characteristic performance resembles the approach of the Restatement Second. However, there is a remarkable difference. In Europe, the basic connecting factor is the habitual residence of the party effecting the characteristic performance, while at least the Restatement tends to focus on the place where that performance is to occur. Thus, in principle, for the sale of goods, the controlling factor in Europe will be the residence of the seller, while the restatement will look to the place of delivery. Both approaches can well be defended. The rendering of performance in a certain country arguably involves that country's policies with regard to such performance. On the other hand, objective reference to the habitual residence of the party effecting that characteristic performance will allow for that party to conduct its trade or business on the basis of one law that will generally apply to any contracts concluded by that party, without the need for that party of having to resort to choice of law provisions. This is basically what is considered to be paramount in Europe, because it is generally with regard to the characteristic performance that legal systems will impose a certain legal regime. Thus, it may be argued that the party rendering the characteristic performance is more strongly affected by the choice of applicable law and therefore should be given special consideration. The European approach may be considered appropriate as long as the focus is primarily on the personal effects of the contract on the parties. But we must bear in mind that this approach may not give proper credit to the policies of the state where performance must be made. And we must particularly bear this in mind because I should like to get back on this aspect later on. There are certain categorical exceptions to this principle contained both in the Rome Convention and in the Rome I proposals. The most important class of these exceptions is directed at the protection of the weaker party. This endeavor to protect the weaker party is closely associated with a classic critique against the European approach, namely that by referring to the habitual residence of the party rendering the characteristic performance, it structurally favors the economically stronger party, the most distinctive example being that of the seller in the sale of goods. To counterbalance this bias, there's a particular choice of law rule for consumer contracts where reference is made to the country where the consumer has his habitual residence, as long as there exist certain additional connections to that country, which we cannot discuss in any more detail here. Whatever choice of law rule we follow in this respect, there's always the danger that it will turn out to be too formal in individual cases. This is why, like the Restatement Second, the Rome Convention contains an escape clause, providing that its objective choice of law principles, I quote, shall be disregarded if it appears from the circumstances as a whole that the contract is more closely connected with another country. The escape clause is designed for cases where the application of the law of the party rendering the characteristic performance would be inappropriate with regard to the party's reasonable expectations. So you can all imagine there are many examples of possible applications of that escape clause. However, the escape clause has fallen into disrespect. In its 2005 proposal, the European Commission wanted to do away with the escape clause in contract conflicts altogether. In part, what was at issue here was the classical conflict between predictability and flexibility of choice of law rules. But that is not the whole picture. Another problem was that it had turned out that the escape clause had not been uniformly applied in the different member states. Some courts applied it very restrictively, while others took it as a convenient mechanism to avoid application of the general rules whenever it seemed appropriate to do so, particularly whenever it permitted the court to apply forum law. In order to avoid these discrepancies and to increase legal certainty, the Commission decided to abolish the escape clause and instead leave it to the parties to choose the applicable law wherever the objective rules were not satisfactory. The proposition met with almost unanimous criticism. Choosing the applicable law is not always a realistic option for the parties. Therefore, it seems preferable that the objective choice of law rules themselves leave the necessary flexibility to adapt them in appropriate cases. This may increase uncertainty in some cases, but it is rather here that we should look to the parties to provide for the necessary certainty by deciding in their contract what law is supposed to apply. Thus, the Commission's proposal in this respect moved into a direction which in its rigidity would not present a good example for the United States. Luckily, however, the recent 2007 proposal has heeded the criticism and reintroduced the escape clause, our first case of advanced retreat. But now let us finally turn to party autonomy and its limits. Of course, both the Rome Convention and the proposed Rome regulation recognize the parties' freedom to choose the law applicable to their contract. The principle of party autonomy is so generally accepted today that it is not necessary to go into the details of its justification at this point. The question then, of course, is that of its limitations. Here we are. In US conflicts law, it is a familiar requirement that, for the party's choice of law to be effective, the chosen law bear a substantial or reasonable relationship to the parties or the transaction. In contrast, there is in principle no such restriction to party autonomy in Europe. The parties may subordinate the contract to what is called a neutral law that is connected neither to them nor to the transaction. Allowing the parties to choose a neutral law is one thing. Allowing them to evade otherwise applicable mandatory law is another. Thus, the European approach requires at least one safeguard in cases where it is obvious that the party's choice can only have the purpose of evading mandatory rules. Where all relevant contacts of the case are only to one and the same country, the choice of another law, quote again, shall not prejudice the application of provisions of the law of that country, which cannot be derogated from by agreement. This means that in purely local transactions, party agreement is ineffective to displace any mandatory local law. This is something of an inversion of the US approach. In Europe, the party's choice will be upheld unless there isn't any reasonable relationship to any country. However, just shortly, it should be noted that the notion of a substantial relationship as a positive requirement for choice of law clauses has made a sudden appearance in the latest revision to the Rome I proposal of 2007 with regards to contracts for the carriage of passengers and in insurance contracts. Here the party shall only be allowed to choose the law of a country which is related to the parties or the transaction by a list of certain enumerated contracts. In all other cases, a choice of law by the parties will be ineffective. When discussing the limits to party autonomy in the European Private International Law of Contracts, special mention must, of course, be made of consumer contracts. We have already noted the desire to protect the weaker party in the context of objective choice of law rules. A corresponding protection is presently granted to the consumer as against a choice of law clause under the Rome Convention, which provides that a choice of law clause shall not deprive the consumer of the protection by the mandatory rules of his habitual residence. This resembles the principle recently proposed in Section 1301 of the 2001 version of the UCC. However, there is a marked difference. It is undisputed that the Rome Convention reserves the full scope of mandatory rules existing in the domestic law of the consumer's residence. Thus, there is very little bite to the possibility of choosing the law of another country for consumer contracts. In fact, the system of the Rome Convention does lead to a strange result, and not only because it might make choice of law provisions redundant. Generally, a consumer contract will only contain a choice of law clause if it has been introduced by the other party, the professional. The Convention now turns such a clause against the professional who introduced it. If the choice of law clause has any effect at all, it will only be that any mandatory rules of the chosen law 5 minutes is unfair, but okay. It will only lead to the additional application of mandatory rules of the chosen law over and beyond those of the consumer's law. It is not really clear why the consumer should thus benefit from the protection of two systems. It was for this reason, among others, that the Commission originally proposed to abolish party autonomy in consumer contracts altogether. Consumer contracts would consequently have been not subject to choice of law clauses, and the contract would invariably and exclusively be governed by the law of the consumer's habitual residence. The abolition of party autonomy evidently also qualified as another revolutionary advance in the Commission's proposal, and as such could count on being met with certain reservations among commentators. The most obvious of these concerns was that the new regime would be too restrictive of autonomy. The reply, of course, must be that under the current regime, it is not really clear what useful purpose the preservation of party autonomy on the choice of law level serves, since it cannot accomplish more than any simple modification of dispositive law can do on the level of substantive law. Still, once again, the 2007 proposal has returned to the traditional path. Choice of law shall remain possible even for consumer contracts, but it shall leave unaffected any and all mandatory provisions of the consumer's country of residence. I should like to turn to a final consideration with regard to the limitations to party autonomy. So far, we've been discussing safeguards against the evasion of mandatory rules at large and the protection of weaker parties. We are now entering the territory of public policy. This is, of course, a broad and difficult subject. In this context, I should like to focus on just a particular reservation, which I suspect will be addressed in the following presentations as well, the so-called overriding mandatory provisions. We do have a certain terminological problem because all of these provisions we're talking about are called mandatory provisions, while they refer to different kinds of mandatory provisions. The provisions we are now talking about are defined in the new Article 9 as provisions, the respect for which is regarded as crucial by a country for safeguarding its public interests, such as its political, social, or economic organization. What precisely is meant by this is subject to a perennial debate in Europe, which would take us another few hours to discuss. Academic quarrels aside, there seems to be a common understanding that what we're talking about here in principles are provisions that transcend the private interests of the parties that form the contract and concern public interests. Common examples are antitrust and securities regulations or laws for the protection of cultural property. If we consider the general choice of law provisions, it becomes clear why we have to have a special regime for these rules. With regard to party autonomy, it is clear that it should not be left to the parties to escape application, for example, of laws protecting cultural property by simply providing for the application of another country's law. But even on the objective level, it is clear that, given the European principle, application of the law of the seller's domicile should not really decide on whether that seller may effectively sell cultural property, say, of Nigeria. In that respect, it is clear that what is at issue here is not a limitation specifically to party autonomy, but rather the provision for special public policy concerns that have not been adequately accounted for in the basic choice of law rules for contracts. This problem is addressed by the new Article 9, and is here that the place of performance now has made a very recent reappearance in the Rome I regulation, because Article 9.3 now provides that, quote again, effect may be given to the overriding mandatory provisions of the law of the country where the obligations arising out of the contract have to be or have been performed, insofar as those provisions render the performance of the contract unlawful. This is possibly the special gift of the new version to England, and is possibly, again, too rigid a rule, while of course it will lead to the appropriate results in many cases, but that may be subject to later discussion. To conclude, the theme of the symposium is not only the European choice of law revolution, if there is such a thing, but also possible lessons to be drawn for the United States. As a European conflict scholar, I'm hesitant to propose any lessons that our American colleagues should draw from our system. I would therefore prefer to settle for just a few very, very, very short remarks on what I would like to think are possible assets of the European approach to choice of law in contracts. First, contrast to some stereotypes, I believe that the European experience shows that a rule-based approach to choice of law can strike a proper balance between the necessary predictability of results and sufficient flexibility to provide for particular situations. Second, and more interestingly, European conflicts law has elaborated a differentiated and quite useful system to deal with mandatory rules in their various manifestations. What is happening in Europe in this respect is not classification merely for the sake of classification, but rather an attempt to flesh out different substantive reasons why mandatory rules should be given effect in the international dimension. Do we want to prevent improper evasion of local mandatory rules through choice of law clauses? Do we want to protect the presumably weaker party on the choice of law level? And do we want to enforce specific public policies of the form or even of another country? These are questions that any system of conflict of laws has to answer, even though the answers may differ. Thus, it may very well be that European law grants excessive protection to consumers and is unduly liberal with regard to choice of law clauses in general. But the fact that we may not always have found the right answers does not necessarily mean that we were asking the wrong questions. given the unfortunate fate of the recent attempt to bring the UCC in line with current developments in Europe, I should therefore like to sum up by saying there's no need to dread the Rome Convention. Thank you.
Our last speaker this morning is Patrick Borchers, who is the Vice President for Academic Affairs at Creighton and the Professor of Law. And since he was on notice that he would be getting no time to gather his thoughts, I'll let him speak.
That's fine. Thank you very much. Well, thank you. I'd like to express my gratitude for being invited, and certainly it's an honor to be here. My only regret is my old professor Fritz Younger would have loved this. This would have been exactly the kind of interchange that he sought throughout his career, and I miss Fritz in a lot of ways. But one of the ways I miss him in particular is at things like this, because at the end of any panel like this, there would be a hysterical 5-minute monologue where he explained that everything everybody had proposed, been tried by the 14th century, was a bad idea and should be rejected. I won't attempt to replicate that. I'm going to keep my remarks at a little more general level, and then hope to stand down at time so that we can have some questions. I don't need any convincing on the proposition that Americans have something to learn from Europe. I actually have been interested in that subject for my entire academic career. One of the very first articles I wrote as an academic was in the American Journal of Comparative Law, where I compared the Brussels Convention with American jurisdictional standards and suggested that American courts had a lot to learn from the relative certainty that could be developed at least by having some agreed upon vocabulary and standards. With regard to choice of law, we actually had a pretty good laboratory for that, and I'm reluctant to speak at all about it because we have the reporter for it here at the table. But when Sim was largely responsible for drafting the Louisiana codification on choice of law, one of the things it was in the Louisiana Law Review, wasn't it, Sim, where we had the celebration as Sim moved over to the dark side of academic administration, like I am. One of the things I studied was the affirmance rate of trial courts before and after the Louisiana codification, because it was almost a perfect laboratory, because up until the time of the codification, the Louisiana courts had followed kind of a traditional American interest analysis, and then when Sim drafted the Louisiana conflicts codification and consolidated the gains of some of that, I noticed that before the codification, that trial courts were no better predictors than a flip of a coin as far as what the ultimate result would be. I believe that the reversal rate of trial courts was something like 47%, meaning that, statistically, the trial court's evaluation of how the choice of law issue should come out, at least in reported decisions, was almost entirely random. After the codification, the affirmance rate of trial courts improved to about 85%. So it's certainly, the Louisiana codification is certainly not a return to the first restatement. I mean, they are very modern rules with some flexibility in them. But one of the things that has always impressed me about the European approach is that at least by having a common document from which you can draw, the chances that courts and parties will be able to predict how things will go increases dramatically. One of my critiques negatively of interest analysis has always been that so many different things can count as an interest, and so many things are open to invention and argument by the parties that it makes it very hard to predict. They're what Fritz would have always called jokers in the deck. I mean, it was, you were perpetually playing cards with an unlimited number of jokers in the deck, and it was very hard to predict how things would come. In my paper, I focus more on party autonomy in choice of law, and I'm certainly not going to go into the details of the Rome I regulation, which I assume is going to be adopted essentially in the form that we see it that we see it now, because we've had a nice presentation on that, and I certainly don't want to repeat that. But one of the things I've always thought that would be good for the U.S. to bring into its law is what I call in my paper categorical exemptions to party autonomy. I agree. I don't think anybody needs persuading that at some general level, party autonomy, at least in contracts, is a commercially useful and valuable idea. But again, one of the things that has always impressed me about the European approach is that they were willing to take some categorical exemptions, to say there are some circumstances under which we're just simply not going to honor the principle. And the three I focus on are the mandatory rules idea, which has been expressed already, the consumer's exemption, and protection for employees. Now, interestingly, I mean, there have been vestiges of all of these in American law at various times. We had, I think at one point, a fairly robust exception along the lines of what in Europe would be recognized as being the mandatory rules exception, and this was sometimes was known as the public law taboo, the idea that there were certain kinds of laws like antitrust laws and securities laws that were largely immune from stipulation by the parties, and with regard to consumers, for instance, it was easy to find cases that honored it treated form contracts, for instance, as being largely exempt from the standard rules of party autonomy. But one by one, those have pretty much gone away. In the U.S., I think the biggest marker on the road with regard to public laws was the Mitsubishi Motors case, in which the U.S. Supreme Court allowed for a stipulation to arbitration for an antitrust case. My hopes that consumer exceptions would be recognized here. I'm drawing from jurisdiction, but I think the principle is basically the same. When the Supreme Court in Carnival Cruise Lines versus Chute decided that the Chutes who were taking a cruise on the Love Boat, that they were somehow stuck with a Florida forum as the result of some fine print on the back of their cruise ship ticket, which I pointed out when I wrote on it. They actually hadn't even gotten the tickets until they got down and were almost on the boat. I mean, the idea that this was, you know, somehow the subject of negotiation, that they could have stopped at one of the agents for Carnival Cruise and said, you know, I'm reading very carefully this on the back. I'm not so certain about this Florida forum. Would you be open to something a little closer to where we live? All of that fell on deaf ears with regard to the Supreme Court. And so one of the things I've always hoped that we would draw from Europe is some sense that there just are times when you have to put the brakes on these concepts. And then my hopes were really buoyed when the American Law Institute, overtly borrowed from the Rome Convention with the new version of the Uniform Commercial Code, the new Choice of Law section 1301, which very clearly drew an exception, very much like, I mean, there are some differences in I think the commentary, I think it was Sim who pointed out to me, the commentary actually mixes up some, to some extent, the public policy exception and the mandatory rules. But it was it was a very, I think, solid effort. Nonetheless, at least at the last I looked, every American jurisdiction that has adopted the new version of Article I of the Uniform Commercial Code has substituted the old 1105. The only place that has, to my knowledge, adopted the new version is the Virgin Islands. Every American state has substituted the old version. So it's a flop as far as the U.S. goes. I think we can speculate for a long, long time on why that is. I mean, I think some of it was probably politics. It made for kind of odd political bedfellows. There were some industry groups that were opposed, and there were others who were opposed to the new 1301 on the grounds that actually was, too liberal with regard to allowing party autonomy. So there may be some of that, but I think to some extent it's just some reluctance in the U.S. to adopt anything that we would recognize as being categorical exemptions to party autonomy. So what's to draw on it? The one thing I will say is that we still do in the U.S. have a public policy reservation for choice of law principles, and just because it's a catch-all principle does not necessarily mean that it has to be toothless. And one of the things that I hope can be urged upon American courts is to remember the public part of the public policy. Sometimes we ignore that particular word, but there are rules that have got what the economists would call significant externalities. I mean, they exist not only to deal with the particular parties, they exist for other antitrust laws are a very good example of that. It's not the fact that the fact that Sim and I would, if we conspired together to raise the prices of our case books, I mean, that may seem like a good deal to us, but it's not a particularly good deal for the students who are buying the case books. So there certainly are some circumstances under which parties, even if they view the benefit as being to themselves, ought to be prohibited from that. So one of the things I urge in my paper is that American courts really try to look at the public part of that and perhaps reintroduce some of these concepts that I think could be felicitously borrowed from our European friends. And one little recommendation I have, I guess, for my American colleagues here is, even if you think codification is not likely to happen in your state, one thing I tried, and I come from a fairly small state, at least as far as population goes, Nebraska. I actually took the trouble to write a little law review article in the Creighton Law Review that just for its purpose really was just to synthesize the choice of law rules as they existed in Nebraska. And I laid them out. I mean, it got fancy. I put a little, black letters for some of them, and then they had kind of commentary after that. And I sent it out to every single judge in the state of Nebraska. I have never gotten so many thank you notes on articles in my life, nor have I had an article that has been so frequently cited by courts. I think courts are, even American courts are very anxious to have something to hang on to with regard to this. They're not real comfortable with these more academic approaches, but nonetheless, because of the revolution that Sim accurately described, that's what they're left with. So I think there are possibilities. I think there's a lot to learn from our European colleagues, and I hope that we do learn it, and then with some effort to get things back on time, I will stand down and hope we have a little time for discussion. Thank you very much.
I actually want to open this up for discussion immediately without any introductory remarks. I think it's probably going to work best if the panelists handle your questions directly. I will moderate if that looks like it's, where I already see the Americans and Europeans have split 2-2.
Yes, we have one back there.
Yeah, so notwithstanding the fact that I am a party autonomy person, I actually do think there's good reason to have categorical exemptions for party autonomy, so long as they're made clear, so long as you know ahead of time, that not ex post what those exemptions are. But I wonder whether one reason why you might make distinctions in the U.S. and Europe with regard to categorical exemptions for consumers, one reason might be class actions in the United States. So a company in both Europe and the United States might want a choice of law clause in their contract so that they can conduct business according to one set of rules, but they get to choose the rule, right? It's not like it actually gets negotiated. In the United States, though, if all consumer contracts have the same choice of law clause, that facilitates the ability to have a large class action, which tends to benefit consumers. So one could think of it as a bargain between consumers as a group and companies as a group. But without class actions in Europe, there's not that bargain sense. And so it may be that there's a stronger case for categorical exemptions in Europe than in the United States. The other thing too is, you know, when you sit down and you say, what's the consequence? Within the United States, the variance across the states with regard to consumer protections is actually fairly small. And so the choice of law clause is not making a huge difference with regard to consumer protections. But that might not, I don't know about consumer protection in Europe, but maybe the variance is larger, in which case, again, the stronger case for categorical exemption there.
Yeah, well, I guess I'd say with regard to class actions, empirically, I don't know the extent to which they actually do benefit consumers. I mean, they certainly have some deterrence value, and interestingly enough, my recollection is that a fair number of arbitration clauses have been upheld, so that essentially class actions have gotten shunted into an arbitral forum. But no, that's an interesting point. I suspect you're right that the variance with regard to consumer protection laws is less, but there are others like franchise protection laws, for instance, where there are significant differences between U.S. states. But I'll let others comment as well.
But Erin, does it not work the other way with class actions? In other words, now it's not in your interest, if you are the seller, to have choice of law clauses in your contracts, because that would open the door for class actions.
But interestingly, right, when you actually look at the contracts, and consumer contracts, a vast majority of them do have choice of law clauses. Now they're also trying.
The old ones used to.
Yeah,
now
the old
they're
ones,
putting
exactly
their mess
right.
on, and
So no, they
say,
all have choice of law clauses. What they're getting rid of is the arbitration clauses.
or they prohibit expressly class arbitrations or class
Right.
actions.
Right,
So
that's
now
the
they
move,
get to have
split
their
it.
cake and eat it too. They have choice of law clauses, but no class actions or no class arbitrations.
But okay, so I guess have you seen the Eisenberg-Miller thing about arbitration clauses in contracts, consumer contracts? I mean, what they seem to be finding is that the companies are getting rid of the arbitration clauses because across the U.S., as long as some states won't enforce them, then or won't let them go to arbitration without class actions, they'd rather deal with courts. So they're finding that the companies are actually moving back toward courts, thinking we're stuck with class actions, but they're not taking the choice of law clause out. So that's where you get to the bargain, I think.
Barry?
Well, actually, I wanted to follow up in a couple of ways. One is they haven't really studied, I just happened to see the Eisenberg-Miller paper like last week. They haven't really studied the relationship between arbitration and choice of law. So I think that's something that is still hanging fire. But the point that I wanted to emphasize is one thing I haven't heard through here, and it's something that I don't really know a lot about, so I'm really interested in it, but whether there are both basic substantive and procedural differences in Europe other than regarding choice of law that might play into the choice of law differences between the U.S. and Europe. And so one possibility is that rules for obtaining jurisdiction in Europe may not impose quite the same burden on, say, manufacturers in terms of where they can be sued as rules for obtaining jurisdiction in the U.S. And also, one thing that I've heard, and I don't know this because I'm not, I don't know anything about European tort law, but that deterrence is a less important consideration in Europe than it is in the U.S. And so this goes to Professor Symeonides' point about you might want to give some weight to the conduct regulating jurisdiction, but that may be true in the U.S. It may be truer in the U.S. than in Europe if, in fact, deterrence is less important in Europe than it is in the U.S. So I'm just sort of inviting, because I'm not. These aren't critiques, because I don't know the answers to these questions, but inviting these non-choice of law considerations relevance to the choice of law issues.
Did you want to add to that question before?
Well, I wanted to make a remark on the conduct issue. You criticized the Rome II regulation for not limiting the common domicile rule. But there is an Article 17, which allows the court to take account of the rules on conduct. And we discussed the matter in the forefield, and everybody thought that this would be sufficient. I mean, the common domicile rule has been applied, at least in Germany, for about 30 or 40 years, and there has never been a problem concerning the rules of conduct.
But if you notice, in the final version of round 2, that article was really restricted and made even more timid. They say account shall be taken so much as appropriate, and in the commentary they explain, it doesn't mean you apply them, you really take them into account, maybe. And they say, as a matter of fact, you know. So it really, in the end, the round 2 version of that article, which I know all the other codifications have in a slightly stronger language, is not a rule of choice of law, but rather almost an evidentiary presumption that you will take account of facts as local data, as Ehrensveit used to teach, you know.
But if I drive on the right-hand side in the United Kingdom, this will be unlawful, whether it is as a matter of fact or as a matter of law.
Well, yeah. And that is, okay, if it's pure traffic rules, most courts will take them into account in a serious way, almost apply them. One of the problems I have with the lack of explicit conduct regulating distinction in Europe is the prevailing assumption there that we are only talking about traffic rules. I think the concept, at least in the American version, is much broader. We're also talking about presumptions that attach to violations of certain safety rules. And also think of other contexts like safety rules in work sites and places of work and so on. I give a whole list in my paper of issues that we regard as conduct regulating issues, which would not fall into the narrower category of safety and conduct rules under Article 17.
Yeah.
So,
but you should keep in mind that these work safety rules in Europe are generally considered as being of a public law nature, and therefore as being of territorial application. Thus,
and that's another difference which makes the European classification different from the American distinction. And in the American cases, we are talking not only about public rules and traffic rules, but also about civil rules and evidentiary presumptions and burdens of proof and so on. So it's a broader category. Now, as to whether, you know, it's true, Larry, that, you know, the prevailing opinion in Europe is that the function of tort law is not to deter, but rather to compensate. And you see that in the fact that they don't have punitive damages, they're very much against it and so on. But I think that does not mean necessarily that deterrence is not a proper function of tort law as understood today. And that, you know, conduct and safety rules still have that function of deterring, you know. And that's why as a country would want to insist in the application of its safety rules for conduct that takes place there. It's true that that aspect of it is not being emphasized or not properly understood, I think, but in my experience, I think the failure to differentiate between conduct and safety matters on the other hand and loss distribution matters deprives us of the ability of a more nuanced and rational handling of complex situations.
Well, I just wanted to point out that it's not just about, you know, the conduct and safety rules, but it's the rules regulating the class action or the rules facilitating the class action could differ between the two countries. The rules about remedies could differ just because of the emphasis in greater emphasis in the U.S. on deterrence than in Europe.
Well, and your point about the jurisdiction is linked with it, I think, is right on, because, I mean, there's the rather diffuse minimum contacts notion that we have in the United States will allow for some exercises of jurisdiction that the Europeans would consider to be exorbitant, and that they don't exercise, at least against themselves, under the Brussels Convention, now the Brussels Regulations. So, yeah, no, it's a seamless web. There's no question that it's all part of a, you know, package that isn't really choice of law so much in the abstract as it is the whole litigation environment, so on, but answer from Hein.
Yeah, I think that Larry Ripstein has raised a very important point that the decisions made in the Rome II regulation and also in the Rome I regulation have to be seen against the still very considerable degree of diversity that exists between European substantive law in matters of torts in particular, but to a lesser degree also in contractual law. And this is also related to the issue of party autonomy. As Dean Symeonides has remarked, party autonomy under the Rome II regulation is wider than party autonomy in American tort choice of law. And this is also related to the fact that the boundary between contract and tort liability is drawn differently in the member states of the European Union. If you think of important areas such as pre-contractual liability, there are a number of issues that are considered to belong to the field of torts in France, for example, whereas they are considered to be of a contractual nature in Germany. So if you limit party autonomy only to contract law, then this would work fine in member states which regard these questions as contractual. But if you then litigate in a member state whose judges would rather frame this issue as a case of tort liability or liability sounding in tort, then your choice of law clause would lead you nowhere. You can, to a certain degree, work with autonomous characterization, and there are specific rules now on pre-contractual liability in the Rome II regulation, but if you want to achieve real legal certainty for commercial parties, you have to grant party autonomy in this respect as well. So I do not agree, Professor Symeonides, with your criticism of party autonomy in the Rome II regulation. With regard to the drafting, one may criticize it whether it is sufficiently precise, commercial activity and freely negotiated and all these criteria. But I think this will demand some fine-tuning by courts, but we will work it out. But the basic policy decision to grant party autonomy in this respect as well, and to a wide degree, is still correct, I think.
To add on to the larger legal environment in which choice of law is situated in Germany, and with regard to the greater differences between the different substantive laws, I'd like to return to your suggestion that under the Rome II regulation, even though that is not my area of competence at the moment.
I talked about contracts as well. So
that's right. So this is my revenge. That in Europe the common domicile exception is both too broad and too tight. If we take it too broad, which means I think you were arguing that we should not apply the common domicile to all matters.
Right, issues of conduct
right. We already saw that here we have to see it before the methodological background. We have escape clauses, possibly for certain aspects. We have the possibility to take into account relations to foreign countries on the substantive level. But again, even if we cannot do that, we have to bear in mind that litigation will probably occur when the parties have a common domicile in their country of common domicile. So whenever we restrict application of the law of the common domicile, this will lead to having to find out what foreign law is. So there is a particular aspect of efficiency here to take that exception very broadly to allow for resolution of the conflict in that state under its own foreign law. In the other, on the other side, taking it too tight, you were suggesting, which is very interesting, to take in diversity cases where the parties have a domicile in different countries, the law of one of those countries, whatever it is, as long as it is the same law. But here again, you will have litigation in one country, necessarily. And then you will have to decide, you will have to look into the other system of law, which will mean that you have to have an expert commenting on foreign law, and that again will make litigation more difficult. All of this might be easier within the United States, where you have differences, but there's at least a chance that lawyers or judges or whoever from one jurisdiction will come close to understanding what another state has adopted as its law.
Well, in the interest of full disclosure, too, Sim and I have a particular emotional investment in Rome too, because Sim, Russ Weintraub and I were at the invitation of Diana Wallace, went over and made what we thought were helpful suggestions on Rome 2, which actually seemed to carry the day at the meeting, and they sort of poked their head up for a while before the political process ground them down. So anyway, that's it was interesting to see we do have a lot in common, that your legislative system appears to be every bit as inefficient as ours. So
Nobody says that this business should be easy. Sometimes you have to know what the other law says, but in an adversarial system, at least what we have in the United States, we're pretty confident that the attorney will find out what the law of the other state is and will plead it appropriately if it serves the interest of his client. The problem with the common domicile rule, you're right, there are exceptions. There is the escape clause and Article 17. The problem. Each of those two has problems. The escape is too tight. It has to be that the whole obligation or tort or delict is related with the other state, whereas very often the issue is just, the dispute is about one issue. So that's what makes the escape not easily deployable. And Article 17, as we said earlier, is too timid, too narrow. It doesn't necessarily mean you apply the law in the place of conduct. So these are the problems with that. In the example I mentioned, where they are domiciled in different states that have the same law, what we're talking about is a classic false conflict, and very often the issue is not difficult to ascertain. That is, suppose under the law of each of their domiciles, you may sue each other. There's no immunity, or there is no limit on the amount of damages, but under the law of the place of the tort, there is a limit on the amount of damages, or you may not even sue the guy, So the differences are obvious. You don't need extensive research in foreign law. And this is a classic case of a false conflict. Why should you apply Kenyan law to a dispute between a Belgian and a French citizen if the issue is not anything that involves conduct regulation in Kenya, and it involves only whether there should be a limit on the amount of damages? It's not a complicated question of foreign law. It's easy to ascertain, and I think all that it takes is a recognition that in this case you have a false conflict. Kenya doesn't care what happens between these two cases. So a rule that would be phrased in this way I suggest would produce this result, and you don't have to reinvent the wheel, and you don't have to have great analysis and so on.
I realize Professor Soloman wants to respond to this, but perhaps at the break we have questions here. Yes.
Hi, Linda Silverman from NYU. I have a comment and then a question. The comment has to do with the interrelationship of jurisdiction and choice of law. I mean, one might think for a moment that because of the Brussels regulation, there are actually in Europe more limited options for where you can sue, and so you may need sort of a federal law or national law on choice of law, less in Europe than we need in the United States. And so, in fact, I mean, Symeon's comment about some desire for a restatement or federalization, which probably won't happen in the United States, I think is probably much greater here, not so much because of the diversity of laws, but because for the opportunities of forum shopping. One question that I wanted to ask for a long time, it's prompted by Patrick's reference to public policy, and I noticed neither of you talking about Rome 1 or Rome 2 invoked the public policy exception. You talked extensively about the mandatory rules, but from the sort of outside, from the American side, I mean, I think it's always been very difficult, at least for me, to really sort of understand sort of the difference about how mandatory laws work, this is again categorization, and public policy works, and which of yours fall into either of those categories. For the United States, we lump it all in some sense into public policy, although we have significant relationship unless it violates strong public policy. We don't have the characterization of mandatory rules. So I'd be interested in sort of some observations that you have, how you think about those rules.
In 2 minutes? That's a difficult question. No, well, basically, the public policy exception in traditional European conflict of laws, for example in German conflict of law, is thought to have a negative function. It means that public policy is an instrument which allows the judge not to apply foreign law if it is somehow offensive to basic values of the legal order in which the case is litigated, whereas mandatory laws of the forum, this is an instrument which allows you to positively apply forum law in spite of, for example, a choice of law clause in favor of a foreign
But
law.
if you use the public policy exception, will you, as we think one should in the United States, sort of dismiss the case, or will you nonetheless use it as an excuse to fall back on forum law
You fall
or
back-
some other law?
You fall back on forum law, usually. I mean, there's a discussion whether in some cases you might also fall back on another
We're going
law,
to have that
but-
discussion for several hours now. This is all
Yeah.
your fault. I told you that we would be discussing this for hours, and you asked that question. And so we'll go,
can do it at
after
lunch,
that,
too.
we'll go straight to have dinner. Everybody's excused. No, this is just the classical distinction, and some among them, I myself think that that is a too simplistic view, because actually this is not the way it works. You have this negative effect of public policy simply because you have your own policies that you give effect to. The thing is why probably we, or definitely I haven't mentioned public policy, because I was running out of time anyhow, and because especially in contract law, it doesn't really have any very important function. Even in tort law, I have the impression that the main application is to ward of excessive American damages. And here again, you could say that the negative effect is that we will not have punitive damages. But on the same side, you could say that is our positive public policy that there is only reimbursement for economic going down, whatever the word is, loss, right? And no ordering of public ordering of private behavior by punitive damages. So actually, it is the same thing. What is more interesting, methodologically and substantively, is why and in what cases we apply these public policy rules. And therefore, basically, it's not very interesting to categorize them as mandatory, overriding mandatory rules or public policy, but to flesh out the reasons why we apply these rules. And we have gotten there. And as I said, public policy has a very little role to play, possibly later on when we talk about family law, but not in the law of obligations, contracts, and torts.
Yes. Thank you. I want to ask something about the limits of party autonomy. I expected that this would also be addressed, because if the initial proposal would have been, or would be the final version of the Rome I regulation, then probably we could have spoken of a revolution. And I mean the choice of non-national rules. What do the members of the panel think about this possibility, which, as far as I remember, Fritz Jünger very much favored? The possibility to apply non-national rules, not only in arbitration, but also in litigation.
Well, I personally would favor it at least in the commercial context, to be able to choose the Untitled principles or what have you. I think that would be a step forward for the U.S., but it's not. I think that's probably a minority view in the United States.
The UNITRA principles are fine. The principles of the European contracts law are fine because they're well drafted, neutral, impartial, and so on. The problem with non-state norms, however, is there are so many other non-state norms we don't know about. They're drafted by the credit card industry, the banking industry, and so on. And so I would hesitate to authorize party autonomy without serious restrictions. And when it's combined with arbitration, then you have a totally private lawmaking process and adjudicatory process, that nobody looks over. And so there are excesses and abuses of the system, but among big commercial players to choose these well-established principles, that's fine. That's okay.
Now here goes dinner, because that would be the third aspect of having a revolutionary advance in Rome I and retreat, because in the original proposal that we had a special provision that provided for parties' choice of non-national rules, and now that was withdrawn. Whatever will happen now, the thing is, in my view, but that is possible for my generation, minority view, that basically it is a good thing that this has gone out of the regulations, precisely because we do not really know how to distinguish the acceptable private rules from those that we would not accept as an actual legal order, industry rules, norms, or whatever. And the thing is, of course, that UNIDROIT principles or the European principles are generally considered to be acceptable, but that is because we have all these articles written by professors, and these are the rules that have been drawn up by professors. So I don't really, can we say that this, because it is a very competent body that is neutral, whatever neutral means, and do we really think that neutrality is essential for substantive law rules? Couldn't we have interested parties who know what they're doing also draw up these rules? These are the issues that you'd have to decide on a general level or leave up to courts to decide, and both I don't see very clearly done at the moment.